This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Welcome to the fourth season of Murgitroyd's Innovation Talks podcast. We're delighted you've joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or via @Murgitroyd on Twitter. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hello, I'm David Mansell and I'm a trainee patent attorney at Murgitroyd. I work at Murgitroyd's Newcastle office and I'm delighted to be with Keith Jones today. Hi Keith.
Hi Dave, how are you?
I'm good, thanks. How are you?
Yeah, good, thank you.
So Keith, you're a UK and European patent attorney with many years of experience in the IP industry. You have over 30 years experience in defending and enforcing our clients' IP rights. And it'd be really interesting just to hear the different ways you have had at your disposal to defend IP rights.
Yeah, well, I guess there's a number of ways in which certainly I've been involved in defending clients' IP rights during my time in the profession. As European patent attorneys, one of the common ways is in defending the patents against attacks by third parties. So European patents, after they're granted for a period of 9 months, they're open to oppositions by anybody at all. So typically a competitor or a client may see that a client's been granted a patent and they're not happy about it, probably because it impinges on some work area that they're interested in. And so they'll seek to nullify that patent, in effect, by opposing it and trying to reverse the decision the Patent Office made to grant a patent and to get that patent revoked. So that's probably the most common way. In the UK, we also see a process similar to oppositions called patent revocation. So that's exactly the same thing. Again, a third party may see a patent that they're not happy to have granted because it impinges upon something they're doing or restricts some way in which they want to work or behave, and so they'll try and revoke that patent either through the UK Patent Office or through the courts. And a similar procedure is also very common in patent infringement proceedings. So, for instance, if somebody is accused of infringing a patent, typically they will defend the claim against them by alleging that that patent shouldn't be in existence, that it's actually invalid, and that it should be invalidated as part of those proceedings.
So in terms of European oppositions, how do clients go about finding out what patents have been granted so that they can potentially consider filing an opposition?
There's various searches they can do. Companies like us have specialist in-house search teams who can keep an eye on, say, competitors' patents, or can search for patents that are being granted in particular technical fields, and they can provide, say, landscapes of a particular technical area, and that can provide information in terms of opposition. As I say, the opposition process in the European Patent Office is time limited, so it's got to be within 9 months of the patent being granted. So you have to keep an eye on the patents as and when they're granted. These days, with the advent of the internet, there's lots of searching that people can do for themselves. So there's various databases like the Espasnet database provided by the European Patent Office, where people can go on and search through patent databases and identify patents that have been recently granted, or can keep watches on particular competitors of theirs and look every week, say, at the new patents that they've had granted.
And typically from a client defending a granted patent, what's involved there during an opposition?
Typically the opposition will come in the form of a statement that the opponent, the person that's trying to invalidate the patent, will submit to the European Patent Office. And usually that's quite a detailed technical document which refers to what's called prior art, so earlier patents and patent applications, on the basis of which the opponent believes that the patent shouldn't have been granted in the first place. Having been submitted to the European Patent Office, that's then sent to the patent owner, and it's up to the patent owner to then decide whether they want to fight the opposition or perhaps amend their patent in some way so they can change how their patent looks, so that they can ask the European Patent Office to reconsider and grant it in a slightly different form.
Is it common for a client to have their patent opposed in this way?
I wouldn't say it's common. I think there's a very small number of the European patents granted that get opposed. I think, from my experience, it can be dictated by competitors or technical areas. So some technical areas, there can be an acceptance that there won't necessarily be any opposition of patents, that each competitor within that area will obtain their own patents and they become a way of bargaining between competitors in the future. Other technical areas can be more litigious or more dispute driven, and there seems to be a lot more opposition goes on in those particular areas or between particular competitors who may be fiercely competitive or something like that. So it's not that there's a huge number of oppositions generally. I think it's sort of 5% or something of that order. It's not very significant at all.
So, but do we have a good track record in defending our clients' positions?
Yes, we do. We have a specialist team. Opposition is a unique part of the patent procedure, and we have a team who specialise in looking after clients' needs in that area, and they have a very good track record in terms of defending our clients' patent rights.
So there's obviously some parallels with patent litigation. Are the costs comparable, or is it significantly cheaper?
No, oppositions are not cheap by any stretch of the imagination, but compared to, say, UK IP litigation proceedings, which can cost hundreds of thousands of pounds, opposition proceedings are significantly cheaper. They're more like £25,000 to £30,000, depending on how far you go through the process. They're just ballpark figures, but certainly it's that order of magnitude of difference when it comes to cost.
That's really useful. Thanks, Keith.
My pleasure.
So just to move on to the enforcement side, in terms of advising a client that comes to us with a patent that they want to enforce against a potential infringer, what kind of advice, what kind of involvement would we have there?
It depends largely on the situation, so we would make an assessment of the situation, but it could range from anything like us simply writing on the client's behalf to a potential infringer, through to employing solicitors and or barristers to advise on the case, to then build a strategy of how we go forward. It really comes down to, say, the size of the infringement, the nature of the infringer, what's at stake for the business, and all these other sorts of things. So there's various strategies that we can put together depending on the individual circumstances. But as I say, they would typically start with either written by us or by a solicitor, what's called a letter before action, which would point out to the potential infringer what we think they're doing wrong and what we want them to do in return in terms of stopping and compensating us for anything they may have done already and things along those lines. And again, the tone of the letter and the way in which you present it would depend upon the individual circumstances, and could be something fairly gentle if that's called for, or could be something, particularly robust and aggressive depending upon the circumstances that are involved.
So do you have a practical example of that?
Yeah, so I can think of an instance a few years ago where we acted for a client who had a patent in the automotive glazing area, and they identified a potential infringer who was making a product which went on car windscreens. And on their behalf, we wrote to them, and the people who'd been supplying the windscreen product stopped straight away. So there's an example of a fairly simple dispute where simply by having the patent and attempting to enforce that patent brought about a commercial solution. It brought about stopping a competitor from selling a product that was undercutting our client and damaging their profit.
It's a really good example of the benefits of IP.
The benefits of IP and the fact that it doesn't need to get complex and legally involved and messy in terms of enforcing the patent.
Thanks, Keith. That's really useful. Thanks for your time.
My pleasure.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.